So the fourth court will now call case number 0423-100 CV, the matter of Gulf View Private Investment et al. Versus GC System. Announcements, please.
Private investment, Spice International, Neil Weitzel, Vincent Costantino, and Adam Walkers.
Good morning. Good morning.
Renee Yonta, also Larry Kirk and Dave Jones.
Morning, Council.
On behalf of GC Systems, we also have our corporate representative here. He's here from the Czech Republic, Mr.
Welcome. Welcome to the fourth court in San Antonio, Texas. Any announcements about splitting argument?
Yes, Mr. Emery and I will be splitting 10 minutes apiece. Rebuttal, we're going to say tentatively 5 and 5, depending on how the argument on the other side goes.
Very good.
And may I ask a question, or will we get, I just need to watch the time or like everyone?
We have the lights there, just like a stoplight, red, green, and yellow. And if necessary, we'll extend the time. Depending on where we're at, we tend to pellet questions sometimes that will give you a little bit more time. We'll see how it goes. Look forward to it. Very good. Council may proceed.
May it please the court. This appeal arises from GCS's lawsuit against my clients referred to as the Weitzel appellants and Mr. Emery's clients referred to as Sierra Nova for damages allegedly resulting from Sierra Nova's failure to complete certain repairs and modifications on GCS's aircraft. As the court knows, this appeal involves a host of issues that we couldn't possibly cover in 20 minutes. So in the limited time I have, I'll focus on the legal and factual insufficiency of the evidence to support the jury's veil-piercing findings. And Mr. Emery will focus his argument on issues related to double recovery and, time permitting, on the sufficiency of evidence to support certain of GCS's claims. The jury verdict in this case is so disconnected from the evidence that both the trial court and even GCS reduced the amounts that the jury assessed by over $6 million when the case was in the trial court. GCS voluntarily remitted $5 million and the trial court excluded another $1.6 million from the judgment. But the problems didn't end there. The jury, without any supporting evidence, found Weitzel International and Mr. Weitzel vicariously liable for Sierra Nova's conduct through veil-piercing findings. It's undisputed that my clients weren't parties to the contracts at issue here, and it's also undisputed that Sierra Nova and its successor Innova were separate entities from Weitzel International and Neil Weitzel. As such, Texas law presumes that they are not responsible for each other's obligations. On appeal, GCS's overarching theme is that Mr. Weitzel and Weitzel International should be vicariously liable based on Sierra Nova's conduct, because from the time Mr. Weitzel obtained an interest in Sierra, he was intent on shutting down its modification and MRO operations and using Sierra's MRO resources to develop STCs. GCS characterizes Mr. Weitzel as a mastermind who completely controlled every aspect of Sierra Nova and used it as a facade to carry out his nefarious scheme to collect funds from GCS to support the STC development with no intention of ever completing the work on GCS's aircraft. GCS devotes a significant portion of its opening brief to arguing that Mr. Weitzel and Weitzel International control Sierra Nova including day-to-day operation on GCS's aircraft. But GCS's allegations are unconnected to the evidence. Weitzel International provided financial, accounting, and some legal services to Sierra Nova. But the evidence is uncontroverted that none of the Weitzel appellants were involved in the day-to-day work on GCS's aircraft. More importantly, evidence of control standing alone is insufficient to pierce the corporate veil. The Texas Supreme Court couldn't be clearer on that issue. In SSP Partners, the court stated, "We have never held corporations liable for each other's obligations merely because of centralized control, mutual purposes, and shared finances. Instead, the Texas Business Organizations Act controls here and narrowly limits the circumstances under which corporate affiliates can be held liable for a corporation's contractual or contractual-related obligations." Section 21.223A2 eliminates alter ego, sham to perpetrate a fraud, or other similar theories as bases to pierce the corporate veil with respect to any contractual obligation of the corporation or any matter relating to or arising from the obligation unless the corporate obligee demonstrates two elements. First, that the corporate affiliate caused the corporation to be used for the purpose of perpetrating and did perpetrate an actual fraud on the obligee. And second, that the corporate affiliate received a direct personal benefit as a result. Section 21.223 is the exclusive method for holding a corporate affiliate personally liable and preempts any other liability imposed for that obligation under the common law or otherwise. Because all of GCS's tort claims arise out of or relate to its contracts with Sierra Nova, Section 21.223 applies to all of its claims. So to support the jury's veil-piercing findings, GCS had the burden to prove first that Mr. Weitzel or Weitzel International used Sierra Nova to perpetrate a fraud on GCS, and second, that Mr. Weitzel and Weitzel International received a direct personal benefit as a result. Starting with the second essential element, Section 21.223 doesn't define direct personal benefit, but courts have interpreted it to mean that the evidence must show that the funds derived from the allegedly fraudulent conduct were pocketed by or diverted to the defendant that sought to be held liable. The benefit must be direct. Indirect benefits received from forming or otherwise generally using the corporate form aren't sufficient. And there has to be a direct connection between the asserted fraudulent conduct and the purported benefit conferred. As an initial observation, it's hard to imagine how either Mr. Weitzel or Weitzel International received a direct personal benefit in this case, when the evidence is undisputed that in addition to Mr. Weitzel's initial $3 million investment in Sierra, Mr. Weitzel and Weitzel International loaned Sierra Nova approximately $15 million between June of 2015 and November of 2018. And more than $14 million of that was never paid back and still has not been paid back. Nevertheless, GCS asserts 5 purported benefits that Mr. Weitzel and Weitzel International received, but none of them meet the requirements of the direct personal benefit connected to the contracts that Sierra Nova had with GCS. The first 4 involving GCS's initial payment, the $275,000 refund for the canceled fuel tank modification, and some inconsequential repayments of loans that Mr. Weitzel and Weitzel International made to Sierra Nova were neither direct nor personal because no funds were ever diverted to or pocketed by either Mr. Weitzel or Weitzel International. And GCS's arguments that these funds relieved Mr. Weitzel and Weitzel International of expenses is without merit because neither Mr. Weitzel nor Weitzel International had any obligation to loan Sierra Nova money in the first place.
Counsel, let me interrupt you if I may. How does your veil piercing argument interact, if any, with one, the sufficiency challenges that are raised to the fraud and negligent misrepresentation claim, and then two, the duplicative recovery arguments.
How do they interact? Well, we would not be liable for, they don't interact at all because we would not be derivatively liable for the fraud or was it negligent misrepresentation? What was submitted in the fraud and negligent misrepresentation, where the defendants Weitzel and Weitzel International were listed was for the direct liability. The veil piercing liability was submitted in the other, I believe, questions 44 and 45 of the charge. So the individual blanks in the fraud and negligent misrepresentation questions deal with direct liability, not veil piercing liability. The only other purported benefit that GCS identifies, the $100,000 transfer from Weitzel International from Innova's sale of an STC, doesn't qualify either because it was merely repayment of an antecedent debt. More importantly, it didn't occur until June 8th of 2021. So GCS can't demonstrate that the transfer had any connection whatsoever to the fraudulent conduct it alleges. That is, using Sierra Innova to collect GCS's payment in order to fund STCs. Now, see, I just have 30 seconds. So with regard to fraud, I just want to say that GCS claims that Mr. Weitzel and Weitzel International failed to disclose that first, Weitzel disdained the MRO side of the business and intended to close it, and second, that Sierra Innova lacked the ability to complete the modifications. And the problem with that argument is that neither of those facts is true.
Let me ask you, we understand GC Systems' response generally to these claims about corporate piercing in particular, is that when Weitzel purchased Sierra, it set about to undermine basically Sierra's, or now Innova's ability to actually perform the MRO services. How do you respond to that specifically?
Well, there's no evidence of that. The evidence is actually that when Mr. Weitzel purchased Sierra, I believe in 2015, that he was fine with the other lines of business. There was no indication that he was intent on undermining the MRO or the modification business, and he was fine with those as long as they were profitable. The problem was that they were not profitable. And so he ended up loaning, between he and Weitzel International, loaning over $15 million just to try and keep Sierra Innova afloat. But there was no evidence that he disdained the MRO side of the business. And the evidence also shows without contradiction that Weitzel and Sierra Innova remained committed to finishing GCS's plane, even though the long-term strategy was to shift to the STC development.
Ms. Dunn.
As I understand it, really, it's kind of founded on some duty to disclose, right? The duty to disclose pertinent information that's relevant to the transaction that they argue was allegedly known to be untrue. The inability to actually, with respect to ordering parts or all the other things that they alleged in their brief, your contention is that that in and of itself is not evidence, given those things, the missing the window or order certain parts, didn't do material work on the plane from a certain period of time, failed to preserve the engines, still needed, 4,900 person hours to finish, etc. You're saying that that also is unfounded, either the duty to disclose or that there was no evidence of that?
Well, there's no evidence that that Weitzel or Mr. Weitzel or Weitzel International had that level of knowledge of what was going on. even as late as August of 2017, there's an email from Mr. Weitzel to Gary Buchanan indicating that he had essentially been kept in the dark about the day-to-day operations. The day-to-day operations were left to Sierra Innova, and that was why we didn't have anything to do with the day-to-day work on the airplane.
Very good, Judge Reeves.
Yes, so going back to what you just said, as far as Mr. Whitesell and the Whitesell defendants, that they weren't intent on necessarily closing down the MRO operations. But Mr. Whitesell was really wanting to keep it open as long as it was profitable.
That's correct.
And I think you've also said, in the record indicates that he had made millions of dollars of loans to Sierra Innova.
That's correct.
Was that, and I think I also saw that there were 2 aircrafts that Sierra had at the time and was working on. So these millions of dollars in loans, were those going towards STC development or to work on these 2 aircrafts that I know we have a lot of other issues with?
Well, I think that there may have been some development of STCs, but again, there was always money there and the commitment was always there to finish the 2 aircraft that remained with Sierra and Innova. And there's testimony from Mr. Arders and I believe from Mr. Whitesell as well, that they remained committed to completing those 2 aircraft before switching wholesale to STC development. So the loans, there's no real breakout of where they went, but it's clear that the commitment was there to finish GCS's aircraft.
And GC did give an advance for the work that Sierra was to perform on the aircraft.
They did pay the price of the proposals that was agreed to upfront. Yes, Your Honor.
I have 2 other questions, but I want to make sure who's supposed to address you or your co-counsel. But if it's your co-counsel, please, happy to defer to them on the negligent misrepresentation claim. Is that something in your wheelhouse? Let me just ask.
I can try or I can defer, Your Honor.
On your negligent misrepresentation claim, when you emphasize the term approximate in the agreements, what is that term's limit? So does approximate mean, does that give you 6 months? Does it give you a year? And who decides that limit? Do the courts? Does the jury?
Your Honor, I will probably defer that to Mr. Emery, but I would think it would perhaps have to have some sort of a reasonableness standard.
Second, on your argument regarding duplicative recovery, how does the $1,036,426 in out-of-pocket damages compensate GC system for 1, loss of use, which the jury awarded $750,000 in question number 31, and then 2, lost parts, logbooks, manuals, and engineering drawing, which the jury awarded $200,000 in question 20.
I will definitely defer to Mr. Emery on that question.
Thank you very much, counsel.
Thank
Anything
you.
further? You've got,
Thank you.
how much time did you split? Is it 10? 10, you got 10 minutes for your co-counsel and invite him to the podium.
Good morning, and may it please the court. Your Honor, I'll definitely try to get to your questions as I go.
Why don't we start with them? The first one, I'll repeat it. On the negligent misrepresentation claim, when you emphasize the term approximate in the agreements, what is that term's limit? Does that give you 6 months? Does that give you a year? And who decides that limit? Is it the court, the jury?
Your Honor, I think it would be, it's necessary to take a look at the entire contract. I know the language, the contractual language that you're referring to, and we talk about approximate dates, but I would draw attention to some other portions of the contract that help fill out the nature of what makes this kind of work approximate. I'm pulling up the original avionics contract, which is Exhibit 9 to Applebee's brief. So we know that there's an approximate date given for finishing it. But I would draw your attention on GC System pages 295 to terms estimated delivery schedule and deteriorating wiring. For estimated delivery schedule, it says the estimated delivery schedule is based on components being readily available to complete the installation, no weather delays, and no unexpected issues with the aircraft. Please be aware that on older aircraft, the condition of the wiring can be a mitigating circumstance, which sometimes affects the delivery schedule. So that's a kind of example of the things that the conditions that the parties build in, right? That when you go in to work on an old plane, you just don't know what you're going to find in it. And that happened here repeatedly. We've given a number of citations in the briefs to discussions about squawks, right? Until you open up a plane, you don't really know what's going to happen. And we didn't, Sierra and Nova didn't have a chance to look at the plane until it literally arrived at their doorstep. So approximate, I would say, is an ongoing understanding between the parties. I'm not going to say that it has a hard and fast meaning, but I think what it stresses is that this was a part of the parties' understanding from the beginning. And if I could have your second question?
Second question is on the argument regarding duplicative recovery. How does the 1,036,426 in out-of-pocket damages compensate GC System for loss of use, which the jury awarded 750,000 in question number 31, and 2 lost parts, logbooks, manuals, and engineering drawings, which the jury awarded 200,000 in question.
Your Honor, it may not necessarily completely compensate them for that, but what we have at issue and what I'd like to talk with you about this morning is that when we talk about the contract damages, GCS cannot have all that it wants. To go back, there was a problem with double recovery that pervades this entire jury verdict and judgment. And what should have been a sort of basic contract dispute ended up having a number of overlapping and sprawling tort claims. The jury took the opportunity to fill in a lot of blanks in its 4 hours of deliberations. And what we end up here is with a lot of duplicative recovery that the trial court simply refused to fully elect among. So if I could start with breach of contract. My client Sierra and Nova entered into an agreed summary judgment for breach of contract. So this happened fairly early in the case. So what should have happened at trial would have just been a trial on the damages for breach of contract. However, GCS requested that breach of contract be charged in a particular way that ended up putting forth conflicting theories of the case for the jury. I'm looking at the jury charge, which is Appendix A to our brief. And you see that there are 2 questions here. The first is out-of-pocket damages. Out-of-pocket damages are reliance damages. And the point of them is to put the party back in the position of the status quo ante. So you get back what you paid in reliance on to have the work done, and it puts you back in the original position. As if there had never been a contract to begin with. But you see the second question here is mitigation expenses, reasonable and necessary expenses incurred in attempting to have the aircraft repaired and serviced by Lancair International, which was a third party that eventually completed the modifications. What I want to emphasize is these 2 theories are conflicting. They're inconsistent, and a court errs when it tries to award both. We've cited a case on page 32 of our brief, LSR joint venture, which explains this well. That there the court declined to both restore the initial consideration that was paid by a party and also to give actual damages in the form of mitigation expenses. So right out of the gate, the GSC had proffered conflicting damages to the to the jury. And it simply had to elect between the two of those. You see what happened in blank two, that the jury initially awarded over $6.6 million. Even GCS knew that that amount was not supportable by the evidence. So eventually it remitted 5 million of that, and we had 1.603 million for mitigation damages. When the trial court entered judgment, it made an election. So on that part, the trial court was correct, and it elected the out-of-pocket damages and did not award the mitigation damages. What GCS is asking now is to basically override that election that the trial court made, and to go back in and request a new round of mitigation damages. It suggests a remitter that would involve some part of paying for the plane to be repaired, and potentially a lot more than that. So the breach of contract damages are a first element of that, where there were conflicting claims that would have resulted in an inconsistent way of both giving GCS back the initial amount of consideration it paid, but then also basically paying for it to have a newly modified plane, right, by all the additional damages. That's not the end of the problems when it comes to overlapping damages, because there's also an overlap, and this, I hope, gets to your question, Chief Justice, that between the amount of out-of-pocket damages that are awarded to GCS and then the tort claims. I would assert that all of the tort claims in this case are still pursuing economic losses, which are the same kind of reliance losses that are awarded under out-of-pocket damages. So, for example, the theft of parts on the plane. This was all circumscribed by the contractual relation between the parties. Sierra and Innova are not going to be doing any work on this Cessna aircraft where they're not an underlying contractual relationship that involved them with one another. Furthermore, when we talk about theft, and we've elaborated on this in the briefing, the contracts themselves tell us about the terms of theft and how transfer of title happened. So I look at the very first section of the standard terms and conditions that are attached to each of the contracts that explain that title to a particular part only transfers once it is installed in the equipment. So that was the provision that the parties worked out in order to explain when title changes. Likewise, when Sierra and Innova would take something off the plane, then they would take title to it. Similarly, the negligence claim also involves having to keep planes safe. And here we have not only the one satisfaction rule that's at issue, but also the economic loss rule. If there's one case that I would really encourage the court to look closely at, it's MAG DS Corps, a Northern District of Texas case that involved facts very similar to this case, where there were agreement for modifications, but along the way, the defendant damaged some of the engines. The engines were not a particular term of the contract; they didn't involve engine repair. But the plaintiffs argued, well, this is an additional kind of tort that you took on in the course of it, and so we should be entitled to negligence damages as well. The court held that that was incorrect and dismissed the claim under the economic loss rule. The same with negligent misrepresentation. The jury question number 42 actually asks about economic loss. So all the tort claims involve some sort of economic loss that is overlapping with the breach of contract damages. I see my time has come here, but I'm happy to answer any further questions.
I'll quickly ask you, I don't think you cited the MAG case in your brief. Do you have a cite for that?
It's page 32 of our second brief.
I'm looking at your first.
There's a lot of sites in there.
Very good. Any questions?
Thank you.
Thank you.
Thank you.
May it please the court. First of all, I want to thank all of you for giving us this opportunity to talk to you about this case. I want to start out with, I plan to talk about the overview of the case and a lot of the issues that Ms. Dunn had raised, because I do believe that what they have asked you to do is to look at certain testimony in isolation. They want you to look at comments or testimony made by Mr. Weitzel or Mr. Arters. For example, Mr. Weitzel saying, oh no, I was fine with MOUs as long as they made money. And have you consider that testimony in isolation of the rest of the record. And as this court knows, and in fact, there's an opinion that I thought was really helpful here. It was opinion San Antonio versus Rodriguez. Chief Justice Stone wrote, our now Chief Justice Martinez was on that panel. It's 2013 Westlaw 4682192. And that was a case that was quoting Chief Justice Tom Phillips in the Lozano case. And that's 52 Southwest 3rd 148, where he says, and Chief Justice Stone quotes, material facts can be and regularly are proven by circumstantial evidence. Secondly, by its very nature, circumstantial evidence involves linking what may appear to be unrelated or isolated or insignificant events to establish a pattern. Just the opposite of looking at evidence in a vacuum, in isolation. It was the jury's job, and now it is your job to review this evidence as a whole. There's another layer on that, and that is the fact finder is entitled to consider all the circumstantial evidence and weigh the witness's credibility and make reasonable inferences by the evidence that the jury decided to believe. Inherently, Justice Phillips and Chief Justice Stone reiterate that the credibility of a witness is a fact question, and it's invariably proven by circumstantial evidence. And it is uniquely within the realm of the jury. So let's just take that first example of Mr. Weitzel saying, oh no, I was fine with MOUs if they make money. Here's the rest of the story. Even before Mr. Weitzel purchased Sierra, he and Arters reviewed the financial situation of the company. And at that time, which it was an MOU mod company. That was what it was known for, MROs and mods. At that time, Sierra was so financially distraught that Arters testified that he believed that Sierra was not a viable company and that Sierra was going to go bankrupt and Sierra was going to fold. So this is 2015, a year before GC comes forward and looks at the facade of Sierra, sees it being represented as the premier mod MRO for Citation Jets. And what we already know from the rest of the story is that Sierra was crumbling and that Mr. Weitzel was already propping it up using his own money every month. He was putting his money into Sierra. So mod and MROs were never profitable. Mr. Weitzel also specifically testified, I didn't want the mods and MROs. I had to take them because that was the only way that Huffstetler would sell me part of the business. So the testimony that's just one example of a snippet of testimony from Mr. Weitzel that can't be viewed in a vacuum, can't be viewed in isolation, has to be viewed with the rest of the evidence. And this is really critical because what we know is this, Mr. Arters, who was undisputably in the course and scope of his employment with Weitzel International the whole time that he was controlling this business, He approved the contract. So he approved the contract and took $1.036 million from GC, knowing that this was a company that was on the brink of going belly up. And in fact, just 3 months later, they have a massive layoff. The evidence is that the jury heard that layoff caused Sierra to have even less capacity to perform this contract. Just 3 months later after that, Mr. Weitzel and Mr. Arders requires Sierra to close its Uvalde workshop. That's the workshop that is represented in all the materials. That's the only workshop that is FAA certified. That's where all the mod MRO expertise is located. They fired some of those folks. Now they move it to San Antonio. San Antonio is not a mod MRO facility. It's not certified by the FAA. And there is a plethora of emails that Mr. Weitzel and Mr. Arders and Mr. Costantino were all familiar with. They were getting weekly, daily, sometimes even daily reports that at that particular point, the move had entirely upended what was left of Sierra. Sierra no longer had the capacity, didn't have the expertise, didn't have the machinists, didn't have the equipment. And the Sierra Innova people kept saying to Arders, please, we need more people. We need better expertise. And Arders chose not to hire them. This is the rest of the story. Yes, Mr. Weitzel has snippets of testimony that support his position, but the jury was the ultimate decider of what was credible and what wasn't. And they decided that Mr. Weitzel was not credible. And let me tell you why that's so important. Because here, Mr. Weitzel not only controlled this company, he was well aware of what was going on, and he hid behind Sierra. At the time they approved the GC contract, they were absolutely aware that Sierra was about to go belly up. And even though they had that knowledge, they instead approved the contract and put Sierra out front, essentially created a Potemkin village, a facade, and hid behind that facade. Part of their defense in this case has been, well, we never talked to GC. True. That's part of the fraud in this case, because you were controlling Sierra, and you knew Sierra didn't have the capacity to perform this contract, and you hid behind that facade, and you didn't provide that information that GC was entitled to. They had a duty to tell us because they were controlling Sierra and because they knew, and because they approved the contract. And that's the evidence in the case.
Ms. Yonta, so could you respond to Ms. Dunn's position that it's about piercing the corporate veil? So how did Weitzel and Weitzel International receive a direct benefit? What was the direct benefit?
Thank you for that question. What the evidence with the rest of the story showed this jury is that starting at the very time that Weitzel took the company, or first he purchased half, and then he began to have capital infusions that he sometimes called loans. The jury didn't believe those were loans because they didn't have the usual indicators of being loans. And Mr. Huffstetler testified that those infusions of capital that started every single month in 2015, and you could see the pattern. The pattern was that every month it kept going up and up and up and up. He took money out of his pocket and used that money for his pet project, which was STC development at Sierra. That's the evidence in this case that the jury believed. Then you see the opportunity of GC coming forward and saying, we'll pay you $1.036 million. You'll get that money in June, and that will be to pay for our plane to have these modifications performed. You see Arders approve the contract, and then you see Arders rapidly waiting for that money to come in. When is it? You'll see email after email that says, when is the money coming in? Is it coming in tomorrow? Is it being transferred by electronic transfer? And as soon as it comes in, which is June 14th, on June 15th, he takes those funds and he sweeps almost all of them out of GC into accounts that are controlled by Whitesell. So what you do see in our pattern of Whitesell using his money, paying for Sierra for his pet project, month after month after month, he pays. And then in June, he pays almost nothing. It's not nothing, it's money. I mean, to me, it would be a lot of money, but there's a huge drop in the amount of money that Whitesell had to spend on his pet project in June of 2016. What happens in July of 2017? Right back up. And it continues every single month. So is that a direct personal benefit? Well, I would say, and I think the law agrees that that is a direct personal benefit. Why? Just to give us a simple example, let's say we went out to eat and the bill is $100. And our friend says, hey, you don't pay it, I'll pay it for you. I got it. Did we not receive a direct personal benefit because I didn't have to spend $100? And what Ms. Dunn says, she tries to differentiate this by saying, well, Mr. Whitesell wasn't obligated. That makes it worse. That's exactly right. He chose to spend his money every single month.
Let me
Until
direct your
June.
attention a bit too, if I may. That Whitesell argues basically that the case law requires a showing that, quote, funds derived from the corporation's allegedly fraudulent conduct were pocketed by or diverted to the individual defendant. So they argue, hey, the evidence showing fraudulently procured funds were used to satisfy corporations' financial obligations, then cuts against the notion that the fraud was perpetrated primarily for the direct personal benefit of an individual. So Whitesell argues that two pieces of evidence with client marshals, it should be viewed through that lens, and specifically the GC's initial payment was ultimately returned to Innova. And they elaborate that Sierra was under no obligation to segregate GC Systems' initial payment, and two, Innovative's $100,000 sale of an SGC to Whitesell. They emphasize that this sale was in satisfaction of an antecedent debt. So what is the evidence that GC specifically points to that's in the record that the jury considered that could be evidence, again, to satisfy an appeal that was derived for a personal benefit?
I would first suggest to the court that we look to the statutory language, which says direct personal benefit. There are cases that,
Let's just assume that we get the law.
okay,
But I need from your record, what is the evidence that GC points to that satisfies this jury verdict on appeal?
first, that in June of 2016, Whitesell is relieved of what he was doing, which was to spend about $1 million a month of his own money to keep Sierra propped up.
What evidence what point to me? Is it an affidavit? Is it
There's
testimony?
affidavits that,
Oh.
well, no, there's no affidavits. Judge, this is actually in our brief, but there are multiple pieces of evidence, including documents that indicated that every single month, Mr. Whitesell was putting his own money into Sierra Innova. There are emails confirming that. There's a chart that confirms that. There's Arders who testified that, in fact, that is exactly what Whitesell was doing. There's also the very interesting testimony or evidence of how Arders was rapidly interested in trying to get that money in and getting it in. And then he immediately swept it out. The fact that the money came back later it was never, first of all, the evidence in the case was that even Arders testified that you couldn't tell whether the money that he used later in the month was money from GC or money from somebody else. So
Okay,
that's,
so if your brief.
so that's one.
Because your brief really, I mean, it cites a lot to the record, but it does, and I get that you have caps on your
Yes.
brief. But in going through these claims, if you could summarily point to actually the evidence, what's an affidavit, an email, testimony about these claims, and that's just the personal benefit.
Yeah.
On appeal, what's also says on the, the evidence of actually perpetrating a fraud, right? Evidence of misleading, evidence of, there's some things like a November letter and stuff. I suspect that you're gonna rely on your brief to pointing specifically to that evidence that satisfies that judgment.
I would say our brief, based on limitations, but space limitations, provided some of the sites to the record where this evidence is located. It was a 4-week-long trial and the jury
No, I
heard
get
all of
that.
it.
Yeah.
Yeah.
But-
I would want to point out to the court, if you don't mind. Mr. Weitzel said that he loaned $15 million to the company. He later testified that 14 million remained. That means he got paid back by Sierra $1 million. So he used his own company, Sierra Innova, to pay him back his own loan, if that even was a loan. That is another indication of using Sierra Innova for his own personal benefit. He also used, there's no question, I mean, there is a question here. The jury believed that based on the evidence that Mr. Weitzel was using Sierra to do this pet project, this STC, and he continued to use it in that regard. That's a direct personal benefit. And then the $100,000, that was not an antecedent debt. The jury did not believe that these were in fact loans. And there's evidence to support the jury's verdict on that, including evidence that none of these loans had the indicia of being a loan. There were documents that identified some of the infusions of capital as loan, but those documents didn't have the normal and customary aspects of a loan, like an interest rate or when the loan would be due to be paid back. And then after Weitzel was able to edge out Huffstetler, and so he was the only owner of Sierra, or his companies were the only owners of Sierra, then you don't see any more loan documents, but you still see millions of dollars that were loaned. So
I see 2 minutes are left and there's a couple of other claims I wanted to get you to, if I may. And if I can direct your attention to your Texas Uniform Fraudulent Transfer Act, or the Tufta claim. On your Tufta claim, if Innova returned the 800,000 that was transferred out in 60 days, how did it quote abscond, remove, or conceal it?
The first thing that I'd like to point out is I don't think the jury did not believe that $100,000 was put back in. And there's evidence to support that conclusion. Even if the $100,000 was put back in, there is nothing in Tufta that affords an affirmative defense or establishes that returning the money is in fact a defense to a Tufta claim.
Let me direct your attention to the judgment, because could you tell me where in the judgment there's an award for Tufta damages? Because I know question 43 says yes, but where did I miss it in the final
There's
judgment?
not that is actually a very good point, Chief. The Tufta judgment was affording to GC the ability to obtain injunctive relief under Tufta if we were to see that to be needed in this case. So the judgment does award liability in Tufta, and the remedy that was awarded was the right to seek injunctive relief under Tufta. And that is really what Tufta is supposed to do. Tufta is not really about getting money back. It's really proactive to try and prevent money from being lost. I also-
So you're saying that there was the injunctive relief in the judge is in the judgment
Yes,
even though there's not a money award. Okay,
Correct.
for it.
correct.
Very good.
The last thing that I'd like to do is just point out the economic loss rule does not apply here in any respect. First of all, the economic loss rule at most could apply to unintentional torts. The Texas Theft Liability Act is a statutory claim and is based on intentional conduct. So the economic loss rule has absolutely cannot, as a matter of law, have any application to the theft recovery. As to negligence and negligent misrepresentation, and by the way, I want to point out the site for that. It's LAN, and it is, if I can read this without my glasses, 435 Southwest 3rd, 234. That's a Texas Supreme Court case with it being written by Chief Justice Hecht. So the economic loss rule really focuses on duty. They talk about two elements, but even when talking about those elements, they say the issue here is duty. And that is that the duty is independent of the contractual undertaking. Here, there was that, and the MAD case is really important for us to read carefully because, first of all, the MAD case wasn't cited until the reply brief. But so I didn't get a chance to write about that for y'all. But the MAD case has first of all, it is a federal district court. It's a trial judge who made that decision, not an appellate court. Number two, it also identifies that the economic loss rule does not generally apply. You have to look at the underlying principles. And then very important fact difference. The contract in MAG had a specific provision in it where the contractor promised that if there was any damage to the aircraft, they would repair the aircraft at their own cost. So they placed the issue of ancillary damages into the contract and then took that as a contractual obligation. We have no such thing here. They never argued that here. MAG is interesting, but it is not applicable. What is applicable in MAG is they quote the Texas Supreme Court that says you need to look at the underlying principles. Here, that was done. Here, the negligence and the negligent misrepresentation do not seek damages that arise from the contractual benefit, and that's extremely important. The economic loss, there's another issue I wanted to point out. Everybody says economic loss is what triggers the economic loss rule. That's not correct. It's economic loss of the contractual benefit. That qualifier is extremely important because throughout Texas law, it is very common for there to be statutory schemes that allow both for breach of a recovery for breach of contract and also recovery under the statutory scheme. For example, the DTPA, the Texas Natural Resources Act. Both of those, for example, like if you haven't paid a royalty, that's a breach of contract. But the Texas Natural Resources Act allows you to recover, it has a remedy for the exact same thing. So it's very important for us to realize that the application of the economic loss rule is not generally applied throughout the board. You have to look at the underlying principle, and the underlying principle here is where do these duties that were breached arise from? And the fact is, not stealing, that's not a contractual duty. That's a statutory and common law duty. Not damaging engines that you weren't even touching in this contract. There was nothing to be done with the engines in this contract. And then upper management, I think that's key here. Upper management chose not to preserve those engines. Why? Well, we have to assume a reasonable inference from that is they said, well, it's not part of the contract, so we're not going to do it. Hail damage to our fuselage, which absolutely affects the airworthiness of our plane. We do not want our plane falling from the sky.
I'll let you,
I'm
close.
sorry. You know, this is a case that was tried, it pended for 4 years. There was a massive amount of work done on it by the lawyers before we got to trial. Then it was a 4-week-long trial. Judge Jimenez listened to the evidence. This jury listened to the evidence. They decided that the appellants were not credible, and they believed the rest of the evidence, which is not just factually, but legally sufficient to support this judgment. We do ask the court to consider remanding so that we can address the issue, especially of appellate fees. And we would ask the court to also amend the judgment to award us our mitigation damages. And we thank the court for this opportunity.
Thank you. Forgive me, counsel, did you want to split rebuttal too?
Yes, Your Honor, I'm going to try and get my rebuttal done in 5 minutes, but I may go a little over. So Mr. Emery has
We're
told
here
me,
for you.
Mr. Emery has told me he won't mind if I go a little bit over. So I certainly understand the concept of taking testimony out of context and the concept of circumstantial evidence. The problem is that there have to be reasonable inferences from the testimony for it to withstand scrutiny as sufficient evidence. And here the problem is that this whole narrative from GCS that there was a plan from the inception that Neil Weitzel was going to come in when he purchased Sierra in 2015, and he was going to secretly get rid of the MRO business and put all of his resources, all of the remaining resources into STCs. That simply isn't supported by any evidence in the record, circumstantial or otherwise. There was never any plan initially. The testimony, again, uncontested, is that the long-term strategy was to develop STCs because that's where Mr. Weitzel thought would be the most money. But again, he said he had no problem, and the circumstantial evidence bears that out because the MRO and modification business continued, and the decision to discontinue the MRO line of business wasn't made until late 2016 or early 2017, long after GCS and Sierra had already entered into the initial proposals. The reason that Mr. Weitzel kept investing in Sierra Nova was to keep all of the businesses afloat so that hopefully someday he would be able to realize his long-term goal of developing STCs. There's no evidence in the record, and there's no reasonable inference from any circumstantial evidence in the record that the money was all going from the get-go to develop STCs. Instead, the evidence shows that the money went to pay rent, it went to pay employee salaries, and it went to keep the business afloat. So again, that eventually, if they could ever get past the 2 remaining projects that were in-house, they would be able to focus on STC development. And it became evident that that was not going to happen. And that's when the decision was made. Mr. Weitzel said, I just can't keep putting money into this company that doesn't seem to be able to get its work done. And so I am no longer going to fund it. As far as the direct personal benefits, Again, that has a very distinct meaning under section 21.223. The courts have interpreted it to mean that the funds derived from the allegedly fraudulent conduct were pocketed by or diverted to the defendant that sought to be held liable. And there has to be some direct connection between the allegedly fraudulent conduct and the benefit received. Again, GCS's initial payment, the argument's been made by Judge Jonta that that relieved Mr. Whitesell of having to fund part of Sierra Nova's expenses the month that payment was made. But again, there was never any obligation to begin with for Mr. Whitesell to fund Sierra Nova. So the fact that it relieved expenses is neither here nor there. That's not a direct personal benefit. On top of that, there was no money that went directly to either Mr. Whitesell or to Whitesell International. The same with the other examples that GCS has given about direct personal benefit. $275,000 refund for the canceled fuel tank modification. Again, that was a benefit to Sierra Nova, not to Mr. Whitesell or Whitesell International. And the repayments of the loans that were made, again, were not direct nor personal because no funds were either diverted to or pocketed by Whitesell or Whitesell International. And I see that my time is up, so I will defer the rest.
I have a quick
Oh,
question
yes.
for you. So you've told us that Mr. Whitesell didn't have an obligation, I guess a contractual obligation
That's
to-
correct, Your Honor.
to advance money or to keep Sierra Nova afloat.
Mhm.
But could the jury have looked at his pattern of conduct and lending or providing funds to keep Sierra Nova afloat? Could the jury have looked at that and considered that a direct benefit? When in fact, 1 month in June, he didn't have to front as much money.
I don't think so, Your Honor, because the law is that it has to be pocketed by or diverted to. And the fact that he was relieved of part of his, what he may have loaned in that month doesn't constitute a direct personal benefit to him. And in fact, he loaned millions and millions after that. So I don't think that constitutes a direct personal benefit as that term is understood under the statute.
Thank you.
Thank you, Your Honor.
With respect to the economic loss rule, again, I would emphasize the MAG case is very close on this, but I would also emphasize that this issue, that the economic loss rule doesn't necessarily have to be invoked in order for there to be important changes to the judgment below. The one satisfaction rule is really the overriding principle here. And again, we've laid out that there's a significant overlap between the contract damages and between the particular tort damages. There's one issue I wanted to try to get to that's related to the contract damages, and that is the particular way that the question number 1 under breach of contract is charged. You'll see returning, you have that instruction back in front of you. Number 1 says out-of-pocket damages, the difference, if any, between the value plaintiff paid for the MRO services and the value of the MRO services performed by Sierra or Nova. MRO services has a very specific meaning in terms of the evidence in this case. In particular, one of the people who is most in the know about this industry, Mark Huffstetler, testified that modifications, which is the subject of the 4 contracts at issue, and MRO work are entirely different services. And on pages 28 and 29 of our second brief, we list a bunch of the evidence that distinguishes between MRO services and mods. Why is that relevant here? Well, this particular charge was put forth by GCS, and it has a significant limiting effect in this case. It asked about the difference between MRO services paid for and those provided. The answer, as the court is aware, of this 1,036,428 is an amount that Enova and Sierra stipulated to, is the amount that GCS actually paid under the contracts. So that simply just can't be the number here. That 1,036,428 is the amount of the modifications, not of MRO work. So what we have here is a rendition
Can I
point.
ask you for a timeout?
Sure.
I'm about to hack up.
Sure.
Hold on, excuse me.
Mhm.
Stay there. Stay. My apologies.
Ms. Dunn knows I had the
Yeah,
exact
another
same
minute.
thing happen to me yesterday, so
Allergies.
it's that time of year.
Thank you.
So the point I was making was that the number that the jury gave for out-of-pocket damages just is not supported by the evidence, given what the question is asking. And GCS never actually provided a number for what MRO services were valued at. And that excerpt that I read from the avionics contract earlier is a good example of what would count as MRO. It's fixing the wires that you encounter all on the way, things that are ancillary to the modifications themselves. The final thing I'll point to real quick is
I'm gonna guess that you preserved by submitting a separate jury question? Or did you present another proposed jury question?
we did. We proposed a benefit of the bargain damages. So which we think would have captured more adequately what was at stake, but these particular charges were proposed by GCS.
So it's, in your opinion, not quote hyper-technical as GC would contend, reliance on, again, the argument that you just proffered about MRO and modification, that it's just an opposite.
Well, the sufficiency of the evidence is measured by the court's charge. And here it's clear as day that the court charged them on MRO services, and anyone sitting in that jury box would have heard quite a bit of testimony in previous weeks that distinguished between those two things. So, you know, the conclusion that we'd have to draw from this is that this is once again a place where the jury kind of went sideways and just put in a number that it thought would satisfy it, but it doesn't.
And the consequence of Huffler's own testimony that modifications fall under the broad category of MRO. What's the consequence of that testimony before the jury?
I think Huffstetler distinguished between the two of them. You know, that this question had asked the difference between the value paid for the modifications and the value received, then it would have required a different answer. It still would have been incomplete because, as there's evidence in the trial that when an independent auditor reviewed what Sierra Nova had done, it was found that 43% of the modifications have been finished. And the jury didn't seem to account for that number either. So we think it's a rendition point, but at least a factual sufficiency point. So The very last point I wanted to get to is just to draw the court's attention, again, on the question of overlapping damages to pages 114 to 116 of the GCS's opening brief. And there they acknowledge that if the one satisfaction rule is applied here, that there is overlap between the jury's mitigation damages finding and the TTLA and negligence claims. There are no more questions. Thank the court.
Give me a second, please. I had a question I gotta find.
Good.
Very good. Thank you, counsel.
Thank you.
This case is now submitted and an opinion will be forthcoming. Court is adjourned. Oh. Have a nice day.